Gun rights are on the rise. I want to cover with you today, what new rights do you have when it comes to possessing firearms? Now, I'm going to walk you through all this because there's some new applications based upon some Supreme Court standards that have been set. And really, there's a particular case, a seminal case known as the Bruen case, which is actually New York State Rifle and Pistol Association versus Bruen, that completely changed the landscape of everything related to gun rights in our country, in the United States. So one of the things I want to do is take a few moments here and talk to you about how the new changes in the law can actually expand into even more areas and what I expect to see coming down the horizon. So the reality of it is gun rights are expanding, more rights are going to be available, and under current Supreme Court standard, I believe there's going to be an expansion of additional rights where more people in different situations are going to be able to have the right to possess firearms more frequently, not just at home, but out in public. So let's talk about this. Number one, I want to give you some key takeaways. A lot of times I'll just go through all the case law and then I'll give you the key takeaways. I'm going to give you the key takeaways first, and then I'm going to support it with what we find under the case law, okay? So key takeaways. Number one, here's the first question. Can felons still possess firearms? Now look, the Bruen case that I talked about, which is New York State Rifle and Pistol Association versus Bruen, that particular case did not address specifically that question about felons. However, there's a recent ruling in Texas that says individuals under criminal investigation, under criminal indictment, can still possess firearms. And there's a case known as the Rahimi case that says that you can possess firearms if you have a domestic violence protective order. But currently, under the law, felons are still prohibited from possessing firearms under the historical analysis model. And we're going to go into this in more depth, okay? So that's number one. Can felons possess firearms? No, they can't. But if you're presumed innocent and you haven't been convicted, now you may be able to do that. So then number two, what if you're charged with a crime and you're presumed innocent? This is a big one. This is an area where I believe Bruen can change everything when it comes to this situation. Look, under our Constitution, you are presumed innocent until you are proven guilty. The problem is, it hasn't always worked out that way. Someone who is wrongfully charged with a crime many times will have onerous bond conditions placed on them. They'll have protective orders that are placed on them that will limit their rights to be able to continue to possess a firearm either in their home or on their person, that will now limit their ability to defend themselves. So here's one of the things that we know. Bruen appears to establish a new precedent that would now allow the following areas to be challenged. I expect many criminal defense attorneys to attack exactly these areas. So here is the areas that can be trailblazed to open up more opportunities here to attack and expand more gun laws. Okay, so expand gun rights, I should say. So number one are bond conditions. It appears that based under the Bruen standard, it would be unlawful to put bond conditions of no firearms on an individual when they've not been convicted. For example, let's say that you've been wrongfully arrested. I say wrongfully, but it doesn't matter whether I think you were wrongfully arrested or not. You're presumed innocent. If someone is arrested for, let's say, a felony theft charge or a felony drug charge, most judges, particularly in Texas, are going to always put a condition on their bond saying you are not permitted to possess firearms. Well, under the new Bruen standard, it would appear that could be going away. Anyone who's charged with a crime, for the most part, should be able to maintain a right to possess that firearm under the historical standards that Judge Clarence Thomas gave in his majority opinion in the Bruen case. Okay, so let's keep going on this. But what about conditions of probation? Now, here's the standard. If you actually go back and look at the historical standards for conditions of probation, very rarely did in our history of our country do you see any type of courts putting limitations on someone that's on probation when it comes to gun rights. So one of the things that we find is if it is a nonviolent crime, Bruen would attempt to appear to allow someone to be able to maintain possession of their firearms in that situation. If it's a violent crime, might be a different story. Very different standard when it comes to that. There's historical precedent prohibiting possession of a firearm in cases of extreme violence, okay? So that might be the case where someone's not allowed to do that. But if it's a nonviolent crime, if it's a drug crime, if it's a situation that's involving, say a theft crime or something along those lines, it would appear to set a new standard and provide an expansion in gun rights in that situation. Now, the real question is this, though. Because what we find that I'm going to go over with you in more depth here is the Bruen Standard, the Bruen decision, Judge Clarence Thomas appeared to provide a standard to ask the question, why is it necessary to disarm the citizen? That's the true question. It's not so much saying that there's a presumption we should disarm the citizen. In fact, the standard changes completely because what it says now is there must be a compelling reason provided why we should ever even consider disarming the citizen. And that reason must be compelling. So let's jump into, I gave you some of the big things to think about. Let me jump right into some of the areas to really think hard and long about when it comes to these Second Amendment rulings and why it's important. So last summer, a Second Amendment ruling that I talked about, which was the New York State Rifle and Pistol Association versus Bruen, it fundamentally changed the way that our courts interpret the Second Amendment right to bear arms. Essentially, the Supreme Court ruled that Americans have a right to carry firearms in public for self-defense. Now, Justice Clarence Thomas, writing for the majority, said this, that the Constitution protects an individual's right to carry a handgun for a self-defense outside the home. Now, this is the first time this had really come out in this very specific way, where it was articulated this way by the majority opinion in the Supreme Court. And so, in fact, back in 2010, the justices had clarified a nationwide right to keep a gun at home for self-defense. That was very well clarified back in 2010. But it had been more than a decade since we had heard from the Supreme Court about any new updates on the expansion of gun rights. So now the real question is, can you do that? Can you have that same right to carry the weapon outside of the home? So now look, this New York State versus Bruen case at first glance didn't appear to mean much. But look, if you know anything about New York has extremely restrictive gun rights. And so New York had put a very strong standard on there that the person applying for a license, in order to be able to maintain or to have a right to have that weapon, they must show proper cause to have a specific need to carry the weapon. Now think about that. From a gun rights perspective, why should a citizen have to show cause as to why they can carry a weapon? So the standard came very clearly on that, which is Bruen turned that on its head and said, absolutely not. It's the other way around. It's not you should have to show cause why you should carry a weapon. In fact, it's the opposite. You are presumed that you should be able to carry a weapon without the state providing some proper compelling reason why you shouldn't. Okay, so it changed the law a little bit. Now, the point I'm making is gun rights are on the rise. They've changed substantially with this decision in Bruen. In fact, in the United States versus Rahimi case, a three-judge panel of the U.S. Court of Appeals in the Fifth Circuit, they ruled and struck down a federal law prohibiting possession of a firearm while under a domestic violence restraining order. Now, understand how important this is. This is a big expansion of gun rights in this situation because essentially it was a direct fallout, a direct result of the Bruen case. Bruen, it changed the standard, and once it changed the standard to a historical analysis, Rahimi, the new case in Rahimi, the three-judge panel in the Fifth Circuit, came back and said, now we have to be able to establish, even if you're under a domestic violence protective order, you still have a right to be able to maintain the possession of your weapons. You can still carry a firearm. Now, this Rahimi decision, now let me remind you, because it was the Fifth Circuit, it only applies in Texas, Louisiana, and Mississippi. But this is actually a precursor of more to come. There's going to be an expansion of additional gun rights. Once this standard is put in place and precedent takes hold, you're going to see an expansion of this across the country. And I'm going to show you some other examples of that here in just a minute. Now, while the Supreme Court's Bruen decision lifted most state restrictions on the public carrying of weapons, it also did something quite a bit more significant. It changed the way in which courts evaluate Second Amendment challenges to gun regulations and restrictions. It literally changed the way that it happened. And I'm going to go over this in a little bit more detail with you now. Before Bruen, let me tell you what happened. Before the Bruen decision, before Justice Thomas ruled or gave the majority opinion here, I'm going to tell you the standard. The standard was as follows. There was a two-step framework. Essentially, what the standard was prior to Bruen is that if historical evidence showed that the regulated conduct was outside the Second Amendment's original scope, then the conduct or activity was protected. But if text and history were unclear, here's where it gets into it, then the courts applied what is known as an intermediate scrutiny analysis. So the government, to prevail, had to show that the regulation was, quote, substantially related to the achievement of an important governmental interest. Now, look, I beat you down with a bunch of legal language there, but can I tell you what basically happened? This two-step analysis that took place almost always resulted in the court's ruling that gun regulations would be upheld. In other words, the citizen would be limited in being able to maintain their gun rights in that scenario, okay? But Justice Clarence Thomas changed all of that when he wrote the majority opinion in Bruen, when he said specifically he rejected that two-step framework by calling it one step far too many. Now, what does that mean? Well, let me tell you the new test. So here's the new test that fundamentally changed gun rights in our country. Here's what it says now. The government must prove, big difference, the government must prove that the challenged regulation is consistent with the nation's historical tradition of firearm regulation. Now, why does that matter? Here's the thing. A lot of people got mad about this. This provoked a ton of criticism. There are a lot of people out there that said, how dare he do this? Many people said that history is an imperfect tool for determining the constitutionality of modern gun regulations. You know, you've heard people say this before. They say, well, you know, there were no AR-15s back in the 17 and 1800s. There were no advanced technology when it comes to guns and these type of things as it exists now. So many people found that extremely critical and they gave it a hard time. But the Bruen test is the law of the land. That is currently the law of the land, and every single appeals court must follow that standard. And so let me give you just a quick summary of what happened in Rahimi, okay? The case I talked about earlier in Rahimi, here's what took place. So local police found that Zaki Rahimi as a suspect in a series of shootings back in December of 2020 and in January of 2021. They had a warrant to come search his home. When they came to his house, what they found was a rifle and a pistol. Now look, when they confronted Rahimi about it, Rahimi admitted that they were his and that they were in his home. He also admitted that he was the subject of a civil protective order as a result of an alleged assault on his ex-girlfriend. It was an alleged assault, okay? It was a civil protective order, which means he had not been convicted. He was not convicted of anything at this period of time. So that order, at the time, though, prohibited him, Rahimi, from harassing, stalking, or threatening her and her child. But the order also expressly prohibited him from being able to possess a firearm. So literally, as a result of that, he was not permitted to have that firearm on his person or in his home. And so he was then subsequently arrested, charged with a felony crime, and he ended up being convicted. So he was literally convicted, sentenced as a result of that, and he appealed that. Now, initially that appeal was overturned, or that appeal was denied. But then what ended up happening is the courts ended up taking on that appeal. And here's what they said. Rahimi's right to keep the weapons found in his home was, here's what the standard is now, was presumptively protected by the Second Amendment because those weapons were, here's what they said, in common use. So these weapons were in common use at the time and fell within the scope of the amendment. So notice what's going on here. Totally different analysis. So even though this guy was under a civil protective order, allegedly assaulted his girlfriends, people might look at it and claim that they thought he was a violent person, or might be, but he wasn't convicted. It was a civil protective order, not a criminal one. It wasn't one where he had become a convicted felon. So as a result of that, the courts didn't look at that at all. They didn't prejudice him when it came to that. They looked at the historical analysis, and they said, no. Back in that time, back at the time when this was passed, years and years ago, we go back and look in history, these type of weapons were in historical use, and that would be a normal thing that the founders would have expected. So that's the analysis that we're looking at here. So the panel of judges rejected all of the government's historical evidence and all of the reasons that they gave, and when they used the courts admitted this. In fact, if you read this opinion, Rahimi, it's very clear. They said that, you know what, prior to Bruen, we would have struck this thing down. In fact, we would have ruled that the societal benefits of limiting his Second Amendment rights outweigh whatever rights he thinks he has. But now, through the lens of Bruen, looking through this new court standard that has been passed, now that federal ban on the possession of a firearm, here's what they said, is, quote, an outlier that our ancestors would never have accepted, end quote. So notice what happens here. The Supreme Court, as well as these appellate courts, are looking at it saying, no, you can't just slap these limitations, these gun control. You cannot put that on individuals, even people who have been charged with violent crimes but have not been convicted. they're presumed innocent, okay? So now I'm going to tell you right now, don't count on things staying the same. In fact, if you go look it up right now, you'll find that the Second Amendment Foundation has found that there are at least 50 cases right now in federal court that are going to be challenging current gun restrictions in all states. In fact, let me give you a couple of examples. One of the things that we find is in Rahimi, after Rahimi, a West Virginia judge applying the Bruen Standard struck down a federal law requiring guns to have serial numbers on them, okay? So that law was found to be unconstitutional. And another judge in Texas ruled that individuals under criminal indictments can possess guns. So in Texas, even if you're under an indictment, you're still presumed innocent. You can still possess firearms under that standard about that on that most recent ruling. So the reality of it is, even in more gun control heavy states, you're finding many of these gun control laws that are being challenged and really it's being done very aggressively to expand gun rights. Now look, I know people have different opinions on these things, but the reality of it is this. If you or a loved one have been charged with a crime, do not let the court or your attorney tell you that you do not still have a right to possess a weapon, particularly if you live in the Texas area in the Fifth Circuit jurisdiction. And under the standard of Bruen, it would appear if you're on probation, you should absolutely still be able to maintain a weapon under this standard. You should be able to have a weapon and to be able to have that weapon for self-defense, both at home and otherwise. And then on top of that, if you are on probation or if you're on bond conditions, these are now areas where people can come and attorneys can challenge these limitations and make sure that a court is not unlawfully limiting your Second Amendment rights. Now listen, maybe if you're facing a charge in the North Texas area, don't hesitate to give our law office a call. But I wanted to update you on these amendments, these changes, these new, essentially these new rulings by the Supreme Court, and not just the Supreme Court, but you know how it works when the Supreme Court issues a ruling. Now we get to see how the lower courts, the Fifth Circuit and otherwise, as they begin to administer and apply that new standard, we begin to see an enormous expansion of gun rights. So this is what we can anticipate to see more of in the coming future. So I hope this video was of help to you. If so, subscribe to our channel. Hey, listen, leave a comment, whether you like it, if you like gun control, you'd like gun rights, you don't like it, whatever it is, leave a comment, ask a question. I'll do everything I can to respond back to it. Thanks for watching our YouTube channel today.